Um, Thanks, Kayleen. I'm going to start and then I'm going to hand over to Yvette. So thank you so much for having us. I echo the gratitude of all the other speakers for you, Kayleen, and Lyria and the rest of your team for arranging this conference. And I also acknowledge with great pride and respect that I'm on the lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders, past, present and emerging. So, as we have learnt today, many of the risks of the cyber physical world and that technology that's conveniently referred to as AI, but in fact consists of a variety of algorithmic or software applications, are rising to the forefront of scholarly and policy discourse. Many of those risks of new technologies, AI, are understandably, and the research on them are understandably focused on public-facing issues of surveillance and algorithmic decision-making, along with the risk of manipulation, privacy and bias that are provoked by these applications of emerging technologies. So the work Yvette and I are doing picks up these themes, but we are focused on the private or in-home applications of these technologies. And this is what we're terming our AI in private spaces project. And I'll just note here, we were largely inspired in this project by some of the work that Kayleen did as part of her PhD. So thank you, as well as a number of others presenting here today. So one strand of this work, AI in private spaces, is focused on consumer products and services that use AI to assist consumers in their home, in their homes and in their day-to-day lives. And of course, if we're thinking of in-home and day-to-day lives, we are thinking a lot about women, children, older people and people with disabilities. Now, predominantly these so-called assistive devices include voice-controlled digital assistants such as Siri or Alexa, which enable users to do things such as make and receive calls, conduct web searches, play music, set alarms and reminders. And we discuss these devices, in fact, and some of the consumer protection issues that arise in the paper that you can see on the screen, which is forthcoming in the Cambridge Handbook of Private Law and Artificial Intelligence, which will be coming out later this year. Now, as I indicated, AI consumer products like digital assistants used in the home promise to free consumers from these mundane tasks and assist them in making more informed decisions about all sorts of matters, from shopping to investing. But the products are also a good exemplar of the risk to consumers and the challenges to consumer protection law, and indeed other areas of law arising from digital technologies. And we've heard a lot about the need for a joined up perspective on these risks from the earlier papers, including that from the team working on a joined up law, in fact, of IoT devices. So what we've done recently, though, is we've conducted a survey in collaboration with our colleagues, Professor Megan Richardson and Damien Clifford. Megan's at Melbourne and Damien's at ANU, of 1,000 Australians about their use of digital assistants and concerns about what they do or don't do when using these devices. Now, I'll just make an acknowledgement here to the comments that Ed Santo made about the difficulty of surveying consumers, because to some extent, consumers' responses are always affected by their understanding of the devices. And in fact, one thing we did in this survey had some open-ended questions to try and prompt consumers to explain how they thought the devices worked, because we felt that was relevant in understanding their responses. And in fact, we're also involved in another project, which is trying to rank how people answer questions about AI policy according to how tech savvy those people are. So ongoing work trying to understand people's experiences and perspectives. But we're just in the early stages of analysing the data at this point. So no doubt later in the year, we'll have some more findings. But we'll mention some interesting early insights from the survey, including that just over half of our respondents reported using a digital assistant or smart speaker frequently or occasionally. And in that survey, we were particularly focused on exploring the risks to consumers and the challenges that consumer law might face when we consider digital assistants. And we were asking this question to a range of consumers, and as Yvette will discuss later, including consumers with disabilities. And at this point, I'll hand over to Yvette.
Thank you, Jeannie, and hello everyone from Lutruwita, Tasmania. I'm here on the land of the Palawa people, and I pay my respect to elders past and present. I tossed and turned all night in fear of the doomsday bell, so hopefully it will not toll for me, but we'll wait and see. So Jeannie mentioned we've been interested in a number of risks to consumers and challenges in relation to these AI in the home devices. And I'll talk you through 3 of the risks that we discussed in the book chapter that Jeannie mentioned to begin with. The first are risks inherent in data-driven technology, and these include some of the sorts of risks we've heard quite a bit about already in this symposium. So risks in terms of the erosion of privacy, which is the concern of data protection law, and the potential for these devices to perpetuate undesirable bias and unlawful discrimination through either encoding the biases of the people creating or applying an AI-enabled system, or through the use of unrepresentative or biased data to train the system. And as we know, these concerns are the primary domain of anti-discrimination law and some other areas that we find in human rights law as well. And so in terms of our survey results, they indicated that privacy concerns are certainly a live issue for consumers. Of the people who said they don't use a digital assistant, nearly 30%, 28.2%, said one of the reasons for this was concerns about their privacy. Of respondents who did, on this slide, who did occasionally or frequently use a digital device, nearly 17% were not at all concerned about privacy, 27% were slightly concerned, almost 32% were moderately concerned, and nearly a quarter were either very or extremely concerned. Between 45 and 50% of respondents who use digital devices were concerned about the device overhearing conversations, or were concerned about the device recording or collecting data about them without them knowing, or were concerned that they didn't know where or for how long recordings, data, or other information would be stored, or for what purpose. And just over 40% of users were concerned about not having control over what happened to their recordings or other data or information. And concerningly, 65.5% of people we surveyed who'd used a digital device reported that they didn't know whether they could change the privacy settings, and another 11% saying they thought that there was nothing they could do to change the settings. And so alongside these risks associated with data-driven technology, we're also interested in a second set of risks arising from AI consumer product status as products. So they may not work very well, they might be unreliable or unsafe, or they might fail to live up to representations about their utility. And the relevant legal responses to these problems and the extent to which existing regulation can respond to new technical demands vary according to whether the issue in question relates to the status of the product as a good or a service. We won't get more into that during the presentation today, but can discuss it, and it's in our Cambridge Chapter 2. And so while we didn't ask consumers in the survey about legal issues specifically, it did indicate that consumers are having mixed experiences in terms of the usability of these digital assistants. So of respondents who frequently or occasionally used such a device, about 56% reported that it worked well or very well, and a bit over a third said it worked adequately. Around 47% of frequent or occasional users said they were very or extremely useful. 37% considered them moderately useful, and around 13% slightly useful, with a small proportion saying they weren't useful at all, presumably because most of them just aren't using them. Of those who said they didn't use such a device, the majority, so 2/3, said they weren't interested, and that was why. And only about 6.4% said they'd tried one and actually didn't like it. And so we deal with those 2 risks in other work, and we're interested as well in risks in this third sphere, which is what I'll focus on for the rest of today. And this relates to the fact that AI consumer products are often promoted, as Kayleen mentioned, for their potential to facilitate or improve social, market and other forms of participation for some people, including some people with disability. And so devices like digital assistants, as Jeannie outlined, certainly offer the potential to assist people with everyday tasks. But there's been little research on the functionality or fitness for purpose of these mainstream devices in these roles, and equally little interrogation, I suppose, of whether they're genuinely accessible and equitable. And this means that there are real risks for AI consumer products failing to meet assertions about their enabling potential. And we certainly see advertisements for these products often highlighting their accessibility benefits for people with disability as a sort of feel-good selling point. But it's unclear, for example, whether voice assistants are responsive to the full range of voices of people with disability. And there is research indicating that they don't work well or at all for some people with speech impairment or some people who are deaf or hard of hearing. Concerns about privacy and surveillance that arise for all users of digital assistants, so having a speaker listening in your home potentially all the time, can be exacerbated for people with disability. For example, where a person feels that they have to choose between maintaining their privacy on the one hand and accessing life-enhancing assistance on the other. Or in circumstances where a person's impairment might mean that another person, like a support worker, sets up the device for them without discussing privacy or other settings. And researchers have also raised concerns that the data used to train AI-enabled systems is not representative of the population in general, and in particular doesn't include a representative sample of people with disability. And this, of course, has the potential to produce inequitable outcomes that reinforce the exclusion of people with disability. Where there's no data on a group, there may be no recommendations or outcomes from the device that are suitable for them. So they may simply miss out, or they must make do with suboptimal results. And there are no easy solutions to these concerns. From a consumer protection and indeed a human rights perspective, it's important not to exaggerate the capacity of AI consumer products to change people's lives, unless there's strong evidence that this is possible, and also that people with disability and other consumer groups who are being targeted or promoted as beneficiaries have been consulted and have indicated that this is something that they want and will use. And disability human rights law does offer one approach to developing products and services that are informed by the community's needs and are more widely accessible. And this is known as universal design, which I know many will be familiar with. And universal design is defined in the UN Disability Convention as the design of products, environments, programs, and services to be usable by all people to the greatest extent possible without the need for adaptation or specialised design. And Connell and colleagues have explained that this requires a range of features, such as products that are useful and marketable to a range of people, that accommodate a range of preferences and abilities, and that minimise hazards and adverse consequences of accidental or unintended actions. And all of this, as I've already mentioned, is only possible with high levels of consultation and collaboration with end users in the design process. We've also considered the utility of principles developed under the field of inquiry into AI ethics in terms of their ability to provide guidance that we don't currently find, at least explicitly, in consumer protection regimes on some of these issues. And these principles of AI ethics have been put forward as a way of responding to the risks of increasing human reliance on AI. And while there have been many formulations of these principles, there are some common themes. So they typically emphasise the need for emerging technologies to respect values of privacy and fairness, or an absence of bias, along with equity and accessibility, safety and reliability. And these principles also typically require AI to be transparent or explainable, and to provide mechanisms for ensuring accountability and contesting adverse outcomes. And in the Cambridge book chapter Jeannie mentioned, we discuss why and how this is different to disclosure as well. In relation to people with disability and the accessibility and benefits of AI consumer products, greater transparency and explainability around design features and through auditing outcomes may inform the robust assessment of claims of accessibility and equity. And this means looking at both how the product should work during design and then how it actually does work in practice. So harking back to the universal design principles that I mentioned a few minutes ago. AI ethics considerations are also relevant for some of the more profound risks of harm to individual autonomy and well-being that we consider might arise from AI consumer devices deployment in the private sphere of the home. So, for instance, most frameworks of AI ethics include principles relating to beneficence. And this aspiration to a positive obligation to do good goes beyond most consumer protection statutes, which typically focus on avoiding harm. And the ethical principle of beneficence might mean refusing to deploy or rely on AI in some circumstances. And we suggest, following John Danaher, that the answer lies in being discerning in the use of AI and, for example, preserving for humans the personal tasks that carry value, primarily because they are done by an individual, and may become inherently uncaring if outsourced to a machine. So, for example, programming a digital assistant to say goodnight to a child will usually not carry the same moral worth and relational weight as the parents saying goodnight themselves. And the same could probably be said, for an example, in the chat earlier about getting a drone to drop the kids off to school. Similarly, we might ask if reliance on digital assistants might facilitate or exacerbate isolation and loneliness before we deploy them in pursuit of more efficient models of care for older people and people who are isolated for other reasons. And all of this suggests that, as we would expect, consumer law doesn't have all the answers to questions arising in this growing space, but it will complement other regimes, including data protection and human rights law, in addressing the increasingly widespread use of emerging digital technologies in market and civic dealings and the risks to consumers associated with it. In our opinion, a key challenge in this context is to equip those enforcing the law with the tools to identify and respond to significant consumer harms that stem from the use of AI consumer products in the domestic sphere. And the other is to address and contemplate these more existential questions about the relationship that we as humans want to have with the disembodied machines that are embedded in our homes and private lives. And that's all for the formal part of our presentation, and we look forward to your questions and comments. Thank you.